Good evening. This side, Rahul Magan here is a Group Chief Executive Officer, Treasury Consulting. As we speak, Treasury Consulting is a multi-asset and multinational hedge fund. We taking positions in multiple asset classes of the globe. But like I repeated many a times, and I would continue to repeat all the times, that we are a proprietary hedge fund. By proprietary, I mean to say that no third party can invest capital in our funds. Please take a note of that. Unfortunately, it's around 5 crore cases which are pending in various levels of Indian judiciary. But having said that, the other side of the coin is Honorable Supreme Courts and Honorable High Courts are working at their best to stop this menace. More importantly, Honorable Supreme Court and High Courts are working and setting up a live examples. I'm really thankful to our Chief Justice, Chandrachud sir, because almost every day he is in media, his remarks, his citations, his positive motivation to the law students, the kind of examples he is setting in just 100 days in his office is exemplary. I personally feel that thanks is a very, very low regards to his efforts. And I really thankful my gratitude to his efforts as far as in the last 100 days are concerned, like RTI portal, ESCR, judgments in multiple languages, judiciary should be reaching to people, not people should be reaching to judiciary, and multiple efforts our Chief Justice sir is taking into consideration. On the other side, our Honorable High Courts are also setting up a live examples. Very recently, Honorable Mumbai High Court set aside the I would say a judgment by Reserve Bank of India, rather quashed the order of Reserve Bank of India, which saved near about 8,400 crores of investors' wealth as far as the Yes Bank 81 bonds are concerned. Around 9th February 2023, Delhi High Court made a statement about cruelty. And you would be very surprised to know that when I got this document on the internet, because nowadays majority of the judgments are reportable in nature and you can easily take a printout from the internet. We should really be thankful for High Courts and Supreme Court in this regards. And when I took the printout of that document, which is around 15-pager judgment by Honorable Delhi High Court, I was very pleased that out of 15-pager, around 5-pager, which is roughly 33% of the judgment, was about cruelty, which means the Honorable Justice of Delhi High Court spared approximately 33% of the space in defining the cruelty. And this, when I read this thoroughly, I was like beyond glad, because glad is a low remark, because the kind of research I saw in this judgment about the cruelty, the various facts which Supreme Court stated about the cruelty, the various phases of the cruelty, everything was in just 15 pages. And I personally thanks Delhi High Court in this regard. But we also aware that there are ample of fake cases we have in India. We have 498A, IPC 354, 406, 34, 503, 506, 323, DV acts, and there are variety of fake cases we have in India. And I completely agree that Supreme Court is trying very hard to stop these minutes. And today video in this regard only. We all are aware that in a criminal system, you are supposed to file a petition in the relevant court. That's very important, because until you file a petition, take a note that yours, what you're trying to convey to the court will not initiate. So, guys, I can't carry a big book with me because it will create a lot of space. So I carried the short Bare Act. Let me read the 311, which is CRPC 311 for you. Now in CRPC 311, which is a very, very important, I would say, which means that any court at any stage of any inquiry, trial, or other proceedings under this code, which means CRPC, summon any person as a witness or examine any person in attendance, which means in person, through not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine or recall and re-examine any person if his evidence appear to be essential to just decision of the case. This is CRPC 311. I would like to connect this with CRPC 382. Now, this is CRPC 382. Every appeal shall be made in the form of a petition in writing. Please take a note, in writing. Presented by the appellant of his pleader, and every side petition shall, unless the court to which it presented otherwise direct, be accompanied by a copy of the judgment or order appealed against that. Which means every appeal which you are doing should have a petition, right? And more importantly, alongside a petition, you need to carry a judgment also, that because of what impugned judgment you are carrying an appeal. Please to note that the petition is a very important document for both plaintiff and defendant. Now, when you appeal, the plaintiff will file a petition. He will say this is his or her problem, and he would like to appeal against the order either of the trial court. If the case is settled in trial court, he would be going in session. If it is settled in session, he would be going to high courts. If it is going settled in high courts, then Supreme Court of India. This petition is nothing but a gist. This petition is nothing but the fact which he's trying to present in the court of law. But please do note that majority of the times, both side lawyers need to consider one thing, which is that the events, the facts, the witnesses, I would say the evidences, the MOR, which in my parlance is material on record, it should not be false, it should not be fabricated, and it should not be manipulated in nature. Our penal code, which is IPC, Indian Penal Code, which is also known as a substantive act, and our CRPC, which is Criminal Procedure Code, which is also known as a procedural code, we are having variety of I would say the proviso to handle these fake cases. Example, let me study, nowadays I am studying this document. It is not that I do not aware about perjury. It is not that I do not aware about how to handle the fake cases. It is not that I do not aware about how to see what evidences and XYZ are fake in nature. But guys, please do note that as far as the Indian Penal Code is concerned, we have IPC 191, read with 192, read with 193, read with 199, read with 503, 506, and in CRPC, we are having 471, 463, 475, 476. These all cover unlawful, I would say the related documentation. Like, let me study 463 for you from CRPC. Non-compliance with the provisions of section 164 or 281. If any court before which the confession or other statement of an accused person recorded or purporting to be recorded under section 164 or 281 is tendered or has been received in evidence, finds that any of the provisions of such section have not been complied with by the magistrate recording that statement, it may, notwithstanding anything contained in section 91 of the Indian Evidence Act, take in this regard to such non-compliance. Let me study 471 for you. Extension of the date on which court is closed. Where the period of the limitation, please note that Limitation Act 1963 played a very important role in a criminal law system, also in the civil. Unfortunately, people believe that we have a sufficient time for reply. Okay, you may think so, but please refer the Limitation Act also, because in the Limitation Act, everything is given. And how much time do you have, how much time do you need, that's all mentioned in the Evidence Act. Please do take a note of that. We really need to understand that when we speak about the fake evidences, when we speak about the fake petitions, when we speak about, I would say the fake facts, both side lawyers needs to see the petition very, very carefully. Both side lawyers needs to see the petition very, very carefully. Guys, I'll tell you one thing that, kindly see this book which is called The Law of Contempt. Now, I am reading this book, This is called Law of Contempt, and this book is written by none other than a great gentleman who is formerly the Secretary General of Supreme Court of India. So you can very well imagine the gist he put this into this book, and we should be thankful for him. Now, in this book, there is a very important thing which he mentioned, which you can easily see, which is section 191 Indian Penal Code, which is about giving false evidences. Section 192, which is fabricating false evidences. Section 193, punishment for false evidences. Section 194, giving or fabricating false evidence with an intent to procure conviction of capital offense. 195, giving or fabricating false evidence with an intent to procure conviction of offense punishable with imprisonment or life imprisonment. And then the 340. I would like to highlight this very important section. The Apex Court, the Supreme Court of India, made the complete guidelines about CRPC 340. Full guideline. In fact, today I got a judgment copy of the Supreme Court from the internet in which they even linked CRPC 340, read with IPC 195 with the preliminary inquiry. And I've not been able to study this, but I took the printout of that and I would be studying this very soon and try and link this with this book. Guys, please do note that, in short, that giving a fake, fabricated evidence in the court of law is punishable. Indian Penal Code is very, very strict in this regards. So if you are a plaintiff or if you are a defendant, please have a thorough look as far as the petition of either side is concerned. These books which are wrought, the law of contempt, these are very, very good books, very, very good books. The thorough understanding about the contempt of court and everything is there. You can easily see that under which clauses, under which action, under which section, the contempt of court and all these things are there. Like, let me show you one important thing. Even though I'm not done with, the complete contempt of court, guys, strict liability rule. Let me study for you. The strict liability rule means the rule of law whereby conduct may be treated as a contempt of court as tending to interfere with the course of justice in a particular legal proceedings, regardless of the intent to do so. You have true crimes, you have strict liability, you have absolute liability. Everything is mentioned in this regard. Henceforth, it is utmost important for a legal fraternity to understand that what all covers in this, how can we handle the cases, what is contempt of court, what is not contempt of court, how we can put our viewpoint in a respectful manner to the court, how we can appeal, what is 311 CRPC, what is 382, how it is linked with 340, how it is linked with the revisional jurisdiction, which is very, very difficult to understand. Revisional jurisdictional of the sessions. Session means the session court, the high courts, and not to mention the Supreme Court of India. How it links with the Article 141, read with Article 142, Article 144, 145, in case 136, which is special leave petition. These all are very important things. This is what we really need to understand. This is Rahul Magan from Treasury Consulting Group. More videos about the law would be on the cards. And I'm very pleased that, I set up my own Law Academy, which means the Knowledge Academy, which means we would be writing articles, we would be making YouTube videos, we would be sharing the knowledge in the public domain. To contact, you have my number 9899242978. Let me repeat, 9899242978. Thank you.